This is Bloomberg Law with June Grasso from Bloomberg Radio.
Ghislaine Maxwell is serving a 20-year sentence for her role in a scheme to sexually exploit and abuse minor girls with Jeffrey Epstein. This week, Maxwell asked the Supreme Court to take up her appeal of her federal sex trafficking conviction. Her appeal is based on a non-prosecution agreement that Epstein struck with federal prosecutors in Miami in 2007, and Maxwell argues it should have barred her prosecution in New York 14 years later. Joining me is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, start by telling us about this broad non-prosecution agreement that Epstein reached with federal prosecutors in 2007.
The document that's at the heart of the Ghislaine Maxwell appeal to the Supreme Court is a non-prosecution agreement that was signed in 2007 with the U.S. Attorney in southern Florida involving Jeffrey Epstein. And in that case, he was facing both federal and potential state charges. The deal that he ultimately struck allowed him to plead guilty to 2 Florida state charges. And in exchange for that, the Department of Justice agreed not to bring any federal charges against him. But the critical language in the agreement said that the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein. And that is the language that Maxwell's lawyers have latched onto to argue that her subsequent sex trafficking charges in New York were actually barred by that non-prosecution agreement.
How unusual is it to have a non-prosecution agreement made by one U.S. attorney bind other U.S. attorneys in different districts?
That would be highly unusual. As a federal prosecutor, I have been involved in hundreds of plea agreements, and the standard language in all of these plea agreements says that that agreement is limited to the district that is prosecuting you or potentially prosecuting you in that case, and that it expressly does not bind any other district in the country. So to have language as broad as that, which says that the U.S. Attorney in the Southern District of Florida can bind every other judicial district in the United States, is something that would be highly unusual. But nonetheless, the language that was in that agreement is on its face very broad, and that is at the heart of the Maxwell appeal before the Supreme Court.
What about the fact that in Jeffrey Epstein's non-prosecution agreement, U.S. Attorney is also promising not to prosecute anyone else? Does that happen?
Typically, what a plea agreement will say is that in exchange for a plea to a particular crime, the U.S. Attorney's Office will not prosecute that individual for any other crimes related to that criminal activity. It doesn't typically say anything about not bringing charges against any other individual. So in this case, that language is incredibly broad because it talks about not bringing any other federal charges against any unspecified co-conspirators. It doesn't even list who those individuals may be. So it makes that language incredibly broad. And that's why when that case was first appealed to the Second Circuit Court of Appeals, the Second Circuit did not agree that that plea agreement barred the prosecution in New York that was ultimately brought against Ghislaine Maxwell.
That Epstein non-prosecution agreement has been widely criticized. In fact, the Justice Department said in 2020 that then U.S. Attorney for the South District of Florida, Alex Acosta, used poor judgment in handling the case. And the Second Circuit reviewed the NPA before upholding her conviction.
The central question raised by Maxwell's appeal to the Supreme Court is whether a promise on behalf of the United States that is made by one U.S. attorney in one district can bind federal prosecutors in other districts. But it really is more complex than even that, because here it involves not a situation where the individual who pled guilty in Florida is being prosecuted by another U.S. attorney's office in another part of the country. We're talking about another person who was not even a party to that plea agreement in Florida, arguing that the plea agreement with Jeffrey Epstein somehow bars a prosecution of Ghislaine Maxwell in New York many years later. So it would be an incredibly broad reading of that language. And in fact, the Second Circuit Court of Appeals looked at the plea agreement and said that on its face, while it's possible that the United States could conceivably refer to the entire federal government, when they look at the context and the entirety of that non-prosecution agreement, it makes clear that when they refer to the government or to the United States, they're only referring to the U.S. Attorney's Office in the Southern District of Florida. And therefore, that language, as Ghislaine Maxwell's attorneys are arguing, is really being taken out of context because it really involved only the Southern District of Florida. But once again, there's really two questions that are being raised here. One is whether it could apply to other U.S. attorneys' offices as against the individual who's pleading guilty in Florida. But also, here you're talking about another individual, not even a party to the Florida agreement, who's trying to use it as a bar to prosecution in another district.
The Justice Department filed papers asking the Supreme Court not to take Maxwell's case.
Yeah, the Justice Department is opposing Maxwell's petition and essentially arguing that it's clear in the context of that non-prosecution agreement that it was only referring to the Southern District of Florida and was not attempting to bind other judicial districts around the country.
Ghislaine Maxwell's attorneys are saying that there's a split in the circuits, and that is something that the Supreme Court often considers when taking a case. But they receive thousands of petitions every year, and they grant review in fewer than 100. So the odds of the Supreme Court granting review here are pretty slim.
That's exactly right. It's very rare for the Supreme Court to take these appeals. They do receive thousands of petitions. It takes 4 justices to grant review, and it seems, in my opinion, unlikely they're going to take this because while there may be a split in the circuits around the country, this is not an issue that comes up on a regular basis. And I think in this case, the Supreme Court is likely just to leave the Second Circuit decision in place and not take it up.
This case is unusual in a lot of different ways, one being that her attorney not only appealed to the Supreme Court, but also appealed to President Trump, saying, quote, President Trump built his legacy in part on the power of a deal, and surely he would agree that when the United States gives its word, it must stand by it.
Yeah, so what we're seeing here really is a court filing in the form of this petition to the United States Supreme Court that on its face is fairly typical. They're raising a legal issue. They're arguing that there is a split in the federal circuits, which is something that the Supreme Court considers when it decides whether or not to take a case. And they're trying to argue that the question of whether one U.S. Attorney's Office can in fact bind the entire United States is something that's important enough that the Supreme Court ought to take it up. On the other hand, you cannot ignore the fact that there is a political backdrop to this appeal in that there's been tremendous backlash against the Department of Justice and some of President Trump's supporters regarding the decision not to release additional information related to the Jeffrey Epstein prosecution. And all of that is getting swept up in this Supreme Court appeal, which is why we're seeing her lawyer appeal not only to the Supreme Court, but expressly appealing to President Trump. In the reply brief that was just recently filed with the Supreme Court, her lawyer specifically referenced not only the United States Supreme Court, where the brief was filed, but also mentioned President Trump and said, we are appealing not only to the Supreme Court, but to the president himself to recognize how profoundly unjust it is to scapegoat Ghislaine Maxwell for Epstein's crimes, especially when the government promised he would not be prosecuted. So this is a quite direct appeal, not only to the court, but also to President Trump in the hope that maybe he will pardon her or reduce her sentence, because they know that it's unlikely the Supreme Court is going to take this appeal.
The court filing, of course, doesn't refer to the, let's say, unusual out-of-court developments like her meeting last week with the Deputy Attorney General, Todd Blanche, for 2 days. She was also subpoenaed to testify by the House Oversight Committee. and her attorney put conditions on her testimony. In addition to immunity, he wanted to be provided with the questions the lawmakers intended to ask her, and he asked that the deposition be rescheduled until after her appeal is resolved before the Supreme Court. The court won't even be in session until October. Are his requests within the scope of what a defense attorney would normally request if his client, who was waiting on an appeal, was asked to testify before Congress?
Yeah, these are not really unusual requests given her circumstance, but they're also requests that the House Oversight Committee has already determined they would not grant. What the defense lawyer here is really trying to do is to protect his client, who is actively seeking post-conviction relief, both in the pending petition before the United States Supreme Court and in a habeas petition they intend to file. And he is arguing that her testimony before the committee could compromise her constitutional rights, could prejudice her legal claims, and could potentially taint a future jury pool if the Supreme Court were to take the case and overturn the lower court's decision and remand the case for another trial. So those requests are really not unusual, but it was also highly unlikely that they were going to be granted by the committee. The most significant condition that Maxwell's attorneys put on her agreement to testify before Congress was this grant of formal immunity. Now, witness immunity comes in several forms. There's something called transactional immunity, which is a blanket or total immunity, which completely protects a witness from future prosecution for crimes related to their testimony. Then there's something called use or derivative use immunity, which means that you can't use the witness's testimony or any evidence derived from that testimony against that witness, but does allow prosecutors to prosecute for evidence that is independently derived, separate from the witness's testimony. But what's happening here was that her lawyers were asking Congress to grant this broad immunity in exchange for her testimony. And that's something that Congress was likely unwilling to do. And in fact, the committee has already rejected that request.
Bob, another thing that's been going on is that the Justice Department has asked judges in Florida and Manhattan to unseal grand jury transcripts in both the Jeffrey Epstein and Ghislaine Maxwell cases. And we've talked before about how you're not going to learn much in those grand jury transcripts. And now we found out that the grand jury transcripts that the Justice Department is seeking only include testimony from two witnesses, both of them law enforcement officers. Law enforcement officers often testify, but what kind of information are you going to get from them?
So there are essentially two ways that prosecutors use grand juries. One is as an investigative tool. The other is as a means for obtaining an indictment. Most of the time, prosecutors use the grand jury for that second purpose, simply to obtain an indictment, because under the Constitution, prosecutors do not have the ability to bring charges directly against individuals. Only a federal grand jury can do that in federal criminal cases. So what prosecutors have to do when they're ready to present their case and ready to bring charges against an individual is bring a witness into the grand jury, generally a law enforcement officer, an FBI agent, a DEA agent, or some other representative of a federal agency. And that witness can effectively summarize the entire case and the evidence. And by doing that, they can summarize witness testimony. They can talk about documents they reviewed. But that is really a high-level summary of the evidence, and it is just enough for prosecutors to obtain that indictment. It is by no means a complete recitation of all of the evidence the prosecutors have, and it is certainly not a complete recitation of all of the witness interviews that were done in connection with the investigation. So it really is a very targeted presentation in front of the grand jury. Sometimes witnesses are used in order to actually conduct an investigation, but it's unusual, and it's usually done in order to lock in witness testimony. If a prosecutor believes that there is an uncooperative witness, that they don't want to be surprised what they're going to say at a trial, if they might testify at a trial, they bring them into the grand jury, they let them testify, even if prosecutors believe that that testimony may be false, but it locks them in. So whatever their story is in front of the grand jury, they can't change it down the road at a trial.
So a Florida judge has already rejected a request for the grand jury transcripts of Epstein's proceedings down there. How likely is it that the New York judges will do the same?
Well, for a judge to unseal grand jury testimony is really unusual. Now, it is left largely to the discretion of the judge, but a judge would have to find extraordinary circumstances. And the fact that there is a strong public desire to get more information about this case really is probably not enough for a judge to agree to release that grand jury testimony. And there's good reason for that, because lots of information and lots of testimony and lots of evidence that's presented in front of a grand jury may mention other individuals who ultimately are not charged. It may mention victims and other sensitive information. And the whole reason that testimony in front of a grand jury is protected by a federal rule known as 6E is because there is a decision that's made, information that does not ultimately lead to an indictment, so an individual has an opportunity to respond to those charges, is not information that ought to be revealed to the public. Because if it is revealed, those people whose names may be mentioned, who have come up in the course of an investigation, really have no opportunity to clear their names, since there'll never be a trial, there'll never be a court proceeding, and it really is simply a guilt by association in some cases, which is what the grand jury is designed expressly to prevent.
A lot of issues around these Epstein files. Thanks so much, Bob. That's former federal prosecutor Robert Mintz of McCarter English. In a setback to abortion opponents, a federal judge this week ruled that Planned Parenthood clinics nationwide must continue to be reimbursed for Medicaid funding. A provision in President Trump's signature tax legislation was written to prohibit Planned Parenthood from receiving any Medicaid funds, even when abortions are not being provided. Massachusetts Judge Indira Talwani found that the provision likely violates the Constitution in 3 different ways. My guest is reproductive rights expert Mary Ziegler, a professor at UC Davis Law School. Mary, how would the Medicaid cuts in Trump's tax bill affect Planned Parenthood?
So I think there are knowns and unknowns. We are pretty sure that it would take away about a third of Planned Parenthood's funding. And what that would translate into in terms of closures is a little bit more complicated and may not be evenly distributed across the universe of Planned Parenthood affiliates. It'll depend on a variety of things like whether fundraising can cover some of those losses, whether Planned Parenthood can try to run out the clock, because at least at the moment, the big, beautiful bill, that provision of it is set to expire in a year, just in time for the midterms. It could obviously be extended, but at the moment it hasn't been. So we do know it's going to have some pretty devastating effects on Planned Parenthood. We've already seen some affiliates close, but exactly what beyond that, I think we still have to see.
Planned Parenthood went to court and argued that the law's pause on Medicaid reimbursements amount to a targeted exclusion that violates the Constitution. Tell us about their arguments.
They argued first that the big, beautiful bill was actually punishing Planned Parenthood for its expression and its speech. So the argument was that the bill was penalizing affiliates not for performing abortions, but for associating with Planned Parenthood, an organization that advocates for reproductive rights. And the logic was Planned Parenthood can't get the money back. An affiliate couldn't get the money back by simply not providing abortions itself. It would have to disaffiliate from Planned Parenthood. There was a related argument under the Equal Protection Clause, and then the final argument that this amounted to what's called a bill of attainder, which is when the legislature punishes someone for past conduct without a trial. So Planned Parenthood was arguing that this bill amounted to a punishment of Planned Parenthood for having done abortions in the past or advocated for abortions in the past. So those were the arguments that are really at the center of the case.
And why did the judge fine for Planned Parenthood?
Yeah, the judge agreed with Planned Parenthood on all 3 arguments, essentially enjoining the big, beautiful bill permanently on all 3 grounds. So this was, at the moment, as big of a win as Planned Parenthood could have asked for.
Was Planned Parenthood saying if the Medicaid reimbursements were stopped, they'd go out of business?
There's varying estimates. I mean, I've heard that a significant number of affiliates would close. It's not really that Planned Parenthood altogether would go out of business because, as the case makes clear, Planned Parenthood is not just a healthcare provider. It's also an advocacy group. And there's no reason to think that every single affiliate will go out of business as a result of the big, beautiful bill. But Planned Parenthood does receive a significant portion of its funding from Medicaid. So we would expect to see a lot of clinics shutter, but how many, I think we won't know unless or until really the bill goes into effect for long enough.
The judge's July 21st order, preliminary order, has already been appealed to the First Circuit. Do you think the First Circuit is likely to affirm this ruling?
It's hard to say, right? I mean, the First Circuit is not known to be a particularly conservative circuit, but some of these arguments are more of a stretch than you might expect. So the unconstitutional conditions doctrine, which is part of what the judge relied on, right, is essentially not that Planned Parenthood has a right to Medicaid funding, but rather that if Planned Parenthood is eligible for Medicaid funding, it can't have that taken away because it exercised this constitutional right to associate. The problem there is that unconstitutional conditions doctrine is just a mess. Like most scholars agree, it's convoluted, it doesn't make a lot of sense, which leaves a lot of room for judges to disagree about how to apply it. And the fight here is really about whether the bill was penalizing Planned Parenthood for providing abortions or whether it was penalizing Planned Parenthood affiliates for associating with an organization that advocated for abortions. And it's hard to predict which way the First Circuit is going to come down on that. Bill of attainder cases are kind of the same, so there's not a lot of law there. It's a little unpredictable.
Just to be clear, Medicaid funds are not used for abortions at Planned Parenthood.
So since the 1976 Hyde Amendment, Planned Parenthood has been unable to use Medicaid dollars for abortions. This is just penalizing organizations that provide abortions by depriving them of Medicaid dollars for other services.
So some states have already cut Planned Parenthood's Medicaid funding, including Texas and Louisiana. And did the Supreme Court open the gate for more states to do that?
Right, exactly, yeah. So in a case last June called Medina, the Supreme Court made it easier for conservative states to kick Planned Parenthood out of their own Medicaid program. So just to be clear, Medicaid is a joint state-federal program. So states have their own Medicaid reimbursement process, as does the federal government. So what states had been looking to do was to prevent Planned Parenthood from getting Medicaid reimbursement for non-abortion services. It had been unclear until June about whether that was permissible, and the Supreme Court just clarified that it is. So one of the upshots of that is that really, regardless of what happens with the big, beautiful bill, either in court or in Congress, right, because this thing is set to expire, and we don't know if Republicans are going to renew it or let it expire because it would hurt them in the midterms. Regardless of what happens with that, we do expect to see more conservative states taking aim at Planned Parenthood when it comes to state Medicaid dollars.
So let's turn now to this wrongful death lawsuit. A Texas man whose girlfriend used abortion pills to end her pregnancies is suing a California doctor who allegedly mailed her the medication. Tell us about this lawsuit.
So this is another interesting lawsuit. It's being brought by Jonathan Mitchell, who is a famous anti-abortion attorney who's probably best known as being the architect of SB 8, the Texas Bounty Bill. But it was filed in federal court, which is interesting, and it argues that a California doctor mailed pills not only to a woman, but a woman and her kind of estranged ex-husband who was pressuring her to have an abortion, allegedly. And that happened and constituted a wrongful death. It's interesting for a number of reasons, because why was it a wrongful death if, in fact, it's not a crime in Texas for a woman to end her own pregnancy? The answer that the lawsuit offers is complicated, but partly that federal law makes it a crime, allegedly, to mail abortion pills at all, right? So this is an effort to turn the Comstock Act, this 19th century obscenity law, into an abortion ban. It's a vehicle for that. And it's also, I think, a vehicle for abortion opponents who are impatient with some of the lawsuits we've already seen. So Texas, for example, has targeted a New York abortion doctor for violating Texas state law. But that's been going quite slowly, right? The action hasn't moved to federal court there. And I think this is an effort to kind of start the process in federal court and maybe expedite the resolution of some of these questions in SCOTUS, especially when it comes to the Comstock Act, but not only to that.
Mary, we've talked before about the threat posed by the Comstock Act on the mailing of abortion pills. It hasn't been used in decades. Does it still stand? Are there any problems with the Comstock Act itself?
Yeah, so it's complicated, right? I mean, the Comstock Act has been enforced in recent decades, but only really in kind of a rare handful of cases involving things like child pornography. So it hasn't been enforced in cases involving abortion, much to speak of at all since the 19-teens. So, there are a number of problems with the argument. It's not clear that the Comstock Act was intended to ban the mailing of all abortion-related items. That doesn't seem to have been what courts thought in the 19th or early 20th centuries. Then there's just whether it's constitutionally permissible to have a zombie law like this kick back in and criminalize a bunch of conduct that everybody thought was fine. Whether that raises due process or fairness concerns is something the courts would have to resolve too. But again, it's not obvious that this case will get all the way to the Supreme Court anyway. Jonathan Mitchell and other abortion opponents have been trying to find a vehicle to get the Comstock Act to the Supreme Court now for several years now, and yet without any success, right? So whether this proves to be the magic bullet, we'll just have to see.
And so he's tried other lawsuits, these wrongful death kind of lawsuits over abortions in state court. Is this a new attempt to take it to federal court?
Yeah, it's a new attempt to take it to federal court. It's also significant who the plaintiff is in this case. A previous wrongful death suit that Mr. Mitchell filed, similarly a kind of man suing his partner. The man ended up having a pretty unsavory background. There were lots of text messages and other data indicating that he had been controlling, that he had done a lot of unflattering and worrisome things that kind of painted the lawsuit in a pretty damning light. So I think this is an attempt to go to federal court to get the Comstock question addressed directly with a plaintiff who isn't as unappealing as the last plaintiff, right? There's an attempt, I don't know if it will work, to paint this as kind of an abortion coercion situation. The lawsuit alleges that the woman having these abortions was being pressured by her estranged husband and to some extent by his family, and that she would have preferred to carry these pregnancies to term. The old lawsuit was very critical of the woman who had the abortion and her friends. So it was sort of, it looked like men telling women what to do. This lawsuit is sort of presenting itself as men defending women against coercive men. Whether a judge sees it that way or whether the facts bear that narrative out remains to be seen.
It seems like the facts are a little odd. She's still married to someone else. Does the boyfriend even have standing to sue?
Right. I mean, genetically, there's an interesting question. I mean, I think obviously, we're in an era now where biological fathers can have rights. It's not just the sort of olden days of marital fathers are the only people with rights in this situation. But to your point, there are interesting questions about whether the plaintiff is in fact a biological father. I'm not sure how that could have been determined.
The facts here seem to leave a lot of open questions. So why bring a suit that you want to gain attention with this fact pattern?
I think the goal is to have a story about abortion coercion. But like you said, it's kind of complicated. A lot of things are unclear, right? Like who was the father of the fetuses or unborn children who were being aborted, right? And how is that being determined? To what extent was there coercion, or to what extent was this just a woman in a complicated romantic entanglement who wasn't sure what the right thing to do was? It was hard to figure out what was exactly going on, even though this was just the plaintiff's version of events. So I imagine that if the plaintiff's version of events is this hard to understand, the reality is that much more complicated.
You mentioned Texas and Louisiana are pursuing legal actions against a New York doctor who prescribed abortion pills to patients in those states. New York has a shield law. So is it a question of which state's law to follow? Can one state tell another state what to do?
Yeah, that's part of the complexity of both this wrongful death suit and the Texas and previous Louisiana cases that we've spoken about before. So when one state is fighting another state, things get complicated under the full faith and credit clause and also choice of law. So the full faith and credit clause says generally that when the courts of one state reach a final judgment, the courts of the other state have to honor that judgment. That's generally how things work. But it gets complicated because there's sometimes exceptions to that rule. And There can be complexities when there are multiple dueling judgments. You could have courts in different states reaching different outcomes. And then those courts have to decide which state's law even apply when they're resolving these questions. So far, the Texas and Louisiana suits haven't gone very far in resolving these questions. They haven't even asked federal courts to get involved. Okay. So I think part of what you're seeing in this case is Jonathan Mitchell trying to go directly to federal court, even though a lot of what he's asking this federal court to weigh in on is state law questions, because a lot of his case is saying this is a wrongful death because of Texas state law, even though there is this Comstock Act claim. A lot of the rest of why it's supposed to have been a wrongful death is based on Texas state law. So it's a little odd that a federal judge is the first person being tasked with resolving those questions. But strategically, I think it's, again, because Mr. Mitchell's interested in seeing federal judges weigh in on the Comstock Act and is probably frustrated that Texas and Louisiana haven't yet escalated their cases to federal court.
So another abortion-related decision, the Court of Appeals for the Fourth Circuit ruled that West Virginia can block access to mifepristone.
Yeah, so there had been several lawsuits that had proceeded in the Biden years arguing that the FDA's rules permitting access to mifepristone under certain circumstances preempted contradictory state laws criminalizing mifepristone, including West Virginia's abortion ban. And the theory was that FDA rules set a uniform federal standard that's meant to govern nationwide, and that state laws, which are trumped by federal law, couldn't conflict with that. And the Fourth Circuit disagreed with that. It certainly doesn't permanently resolve the question. I mean, the plaintiffs in that case could appeal. There are other circuits that could resolve such a question, but it was one of the ways that abortion rights supporters were hoping to use the FDA's current rules on mifepristone to limit state bans, and that hasn't worked to date.
And so what could the state do to make it harder for women to get mifepristone, or since it's going through the mail, right?
So we're seeing a whole bunch of efforts to answer that question, actually, as we speak. One of the most important is taking place in Texas. Texas had a kind of what you'd consider a model bill to target abortion pills. It is kind of a massive bill that touches on everything from the advertising of abortion providers to internet servers that carry information about abortion, to abortion funds that help low-income patients address abortion, to creating a state law equivalent of the Comstock Act. This was sort of like an abortion pill mega bill, right? And surprisingly, this legislation had been introduced during a regular legislative session in Texas, and it didn't pass. So the governor of Texas announced a special session, and it's expected that the bill will be taken up again then. Again, it's unclear whether this bill will pass, but if it does, it could be a model for other states trying to take on abortion pills. The challenge, as you mentioned, is that ultimately these pills are coming from out of state, and without some kind of federal action, either from a federal court or from the Trump administration, and most likely from both, states are still going to be somewhat hindered in their ability to take on abortion pills.
And what's been happening with the abortion trafficking bills in some states?
There have been a bunch of developments. Idaho reached a settlement where it wouldn't prosecute people for referring for out-of-state abortions. There have been a number of challenges to those bills on the free speech side of things that have been kind of going either settled or going the way of abortion providers. So that's another thing to watch, especially as this abortion pill mega bill moves forward in Texas. There's an interesting question about whether that will raise free speech concerns that will eventually doom it, because we're seeing kind of warning signs both in these settlements and in litigation when it comes to free speech and access to out-of-state abortion.
It's hard to keep track of all the different abortion-related issues going on across the country. Thanks so much, Mary. That's Professor Mary Ziegler of UC Davis Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.